Okay, we are live. We are doing a special reading of The Art of Passing the Buck for Wednesday in preparation for Howard next Monday. It's January 3rd, and we left off, I believe, at chapter 11. So that is page 115 on the book. And does anybody want to take their hand at reading this chapter? No takers?
Give me a minute. Let me get my better glasses on, and I'll see if I can take a stab at it to give you a break, okay?
Okay. If not, I think Justin was going to volunteer.
Oh, well, if you'd rather, I'm okay with that too.
No, I mean, you guys can take turns. He can read the next chapter.
Okay, well, I'll start then just to give you a break, okay?
Thank you. Right. I'll read the appendixes if they come up.
Okay. All right. Here we go. Chapter 11, Protector, Judge, and Jury. In some trusts, protectors have stepped in to mediate and resolve disputes. Thus, though the simple medium of personal communication, they have averted further complications. A protector chosen by the grantor can do much to give the grantor peace of mind and help a smooth transition from ownership of material assets to ownership of TCUs. George G. Bogert discusses how a third party can be given the power to remove a trustee. There is no reason to suppose that a power of removal could not be given a disinterested party, nor why it might not be made exercisable without cause. However, it would seem that such a power would be held under a fiduciary obligation to exercise it only in the interest of the beneficiaries.
Okay, so now it's telling us to go to Appendix A, Format 2. Okay. So Format 2 is alternate no heirs. This excerpt came from a different trust where the grantor did not believe any of his children would have children. So you've got the juvenile delinquent. Having been a juvenile delinquent, he always wanted to help those less fortunate. He wrote this into his indenture. This gives you a direct sense of one who has been involved in crime and who has chosen to do better for himself. Use this by replacing his particular charitable sense with your own. Perhaps your concern is with the starving children in India or with supporting gifted children. We hope this inspires you because even if your family has grown over 2 generations, before your trust becomes richly funded, these instructions in your trust give direction about what to do with excess funds. Charitable donations. We have included at the end of Appendix A the beginning of a charitable trust indenture. It is separate from the indenture dedicated to your family. Also, as part of your family trust indenture, there can be another section where you address what to do with funds after they reach a particular cash flow. For example, if the trust earns more than $200,000 a year, you may want to direct the Board of Trustees to give 10% of it to specific charities. In the charity section of your family trust, you can go into detail regarding who is or who is not qualified to receive your bequest. 1. If there are no direct descendants, issue TCUs based on merit or need to organizations supporting first-time offenders. First-time offenders are juveniles and adolescents coming from dysfunctional homes or those who have committed nonviolent crimes. 2. Disqualified from this definition are A. Drug dealers, repeat offenders, murderers, arsonists, hijackers, or those who commit acts of piracy. B. Those who cause bodily harm. C. Criminals who use a gun, whether loaded or not, a knife, or any other weapon. 3. Support the first-time offenders to integrate them successfully into society to become productive and contributing members. This includes educational opportunities, healthcare, mentoring, and other creative participation. 4. Specific organizations now qualified are A, List A, B, List B. And that was it.
Okay. First line of defense. The purpose of the protector is to be the first line of defense to keep the trust safe from litigation stemming from questionable conduct by the trustees or from challenges by the beneficiaries. Although the trust protector is not a member of the board of the trustees, as part of his or her continuing training, invite the protector to attend some of the trust meetings. If the trustees take actions appearing contrary to the instructions of the grantor or the trust indenture, whoever first notices the conflict may call on the protector to review the facts, and if considered necessary, to intervene. The degree of intervention depends on the terms of the indenture and the severity of the possible breach. It may include removal of a trustee or even legal action. Appointed by the grantor, the protector should not hold any more than 1% of the TCUs, if the grantor so chooses. The protector should be beholden to the beneficiaries on behalf of the grantor, and not so heavily invested in the trust. His or her loyalty is split if there is a dispute between the trustees and the grantor. The watchful eye. Set up a trust with enough checks and balances. Although signature power belongs to the trustees, the grantor can often review the accounting or even act as the accountant. Ideally, 2 trustees should sign all the checks and act as a watch on each other. The real test, though, is just how conscious and involved the family becomes. These are the people who receive the overflow from the trust. Here lies the secret of most everything in life. Who is paying attention? This is why the protector becomes intrinsic to the trust's unfolding. Who cannot be a protector? The person with the power to dismiss a trustee cannot personally gain from the act, although there should be an incentive interest in the trust, make it 1% or less. Protectors cannot make their children beneficiaries because the protector may have a motive to dismiss a trustee to replace one who favors his children. The father of another family member of the grantor could be a protector, if he or she can be trusted to not favor any of the beneficiaries, and if this family member has enough education about trust responsibilities. After gaining enough experience about protector realities, we find the more professional the protector, the safer the assets.
Hang on. I totally fell behind. There was a footnote for Appendix A Format 3, and it was in regards to the degree of intervention depends on the terms of the indenture. So that was Appendix A Format 3.
If I miss those little things, just stop me because
I missed it too. So I was like, oh crap, there's an appendix. Okay, so sample format 3, Appendix A, protector. This sample is an evolution taken from various legal documents and hardcore experience, although not perfect yet, and maybe it will never be. Here is information never offered openly in this format. What could go wrong? After reviewing several indentures, this combination of information proved to be the most thorough. It gives you a perspective of possibilities of what could go wrong. From the grantor left, quote, holding the bag, unquote, to the errant trustee, we feel we supply broad strokes to incorporate in your own indenture. Protector selection. This information is applicable to both a private and statutory trust, and you may just save the day if your trust runs into either international or external troubles. When drafting an indenture, use this as a guideline of how to select a protector and who you want to watch over your trust without burdening that person with all the details. Specifically, what qualifications would your protector need to effectively interface with your beneficiaries? We hope that reading through this gives you a deeper understanding of this little-known area of trusts. Okay, so we've got, here, let me just show this. Cancel. Okay. Okay, so you got the protector. A, the protector supports and ensures mediation and arbitration as described in section 12, 13, and 14 and sees to satisfying both parties. B, the protector secures and protects the present and contingent distribution rights of the trust certificate holders. This includes 1, the overall legal status and holding of trust property, 2, protecting the trust from any actions by its fiduciaries which could be harmful or destructive to the trust estate, and 3, actions which might bring discredit on the trust group. C, the protector cannot be subservient or subordinate to any trustee or family member of the trustees. D, the protector can advise the Board of Trustees should the trustees so wish. E, the protector receives at least 1 trust capital unit or 1% as agreed between the grantor and the protector. F, the protector signs a separate agreement that becomes part of this declaration of contract and trust indenture when he or she accepts the position with this trust. G, appointments. Under that, you got grantor appoints the first protector. Then you've got the grantor has the right to choose a succession of at least 2 protectors to be on file within the minutes of this trust. And 3, the grantor reserves the right to set up instructions and standards for choosing succeeding protectors. The details will be in the minutes. H, powers of the protector. 1, the protector has the right and the authority on due cause in his or her sole discretion to dismiss a trustee on written notice, delivery by certified mail to said trustee's address. Due cause can be for violation or lack of fulfillment of the indenture and for behavior which causes dishonor to the trust. 2, the right to change characteristics of the trust to avoid exposure of the assets to risk. This includes a change of trustee, situs, or country. 3, the right to increase or decrease trustees' fees, salaries, wages, and distribution percentages to ensure they are in alignment with cash flow to protect the corpus of the trust for the beneficiaries. 4, the right to ask for an audit of the trust to help teach and develop better protocols to protect the assets, or as part of an investigation into a trustee's conduct. I, limits. Under that, you got the protector is not a member of the Board of Trustees. 2, the protector cannot be a beneficiary, nor can his or her spouse, children, sons or daughters-in-law, mother, father, or brothers and sisters, or anyone to whom the protector may be loyal. J, removal of a protector. 1, the grantor keeps the right to fire or hire the protector at his or her own discretion. 2, the Board of Trustees has the authority to replace a protector on death or resignation only if the grantor is unavailable to choose another. 3, if the removal of the protector is for medical reasons, the Board of Trustees has the power to demand the protector gets a certification of competency to continue to serve in the role of protector. Failure to produce the necessary medical certification within a reasonable named time is an automatic resignation. 4, removal of a protector can be by 1, the grantor with or without cause, 2, more than 2/3 of the certificate holders based on the TCUs held, 3, the Board of Trustees based on satisfactory and enough evidence of unfit or irresponsible behavior such as a drug or alcohol addiction, or B, an illness which prevents the protector from functioning. And then under removal of a protector, we continue on to show all procedures to remove a protector are confidential. And then the minutes of this trust documents the protector removal proceedings. K, removal of a trustee. 1, keep the removal of a trustee confidential. If the trustee so removed wishes the matter kept so, the trustee should so express this wish to the protector or the Board of Trustees. 2, before dismissing a trustee for medical reasons, the protector can insist the trustee gets a certification from at least one doctor stating he or she is fit to serve as a trustee. Any refusal to provide the proper documentation within a named period of time, not to exceed 20 days, is a resignation. 3, the Board of Trustees has the authority to replace a protector on death or resignation, only if the grantor is unavailable to choose another. L, protector's power to remove a trustee. 1, only if the protector does not perform his or her duties in response to the request of the trust certificate holders or beneficiaries will the grantor help with the removal of a trustee. 2, the grantor enters with others to remove a trustee for just cause and under the guidelines set forth within this trust instrument. 3, the grantor holds the power to remove a trustee for violation of the indenture if there is enough documentation to show the following additional circumstances also exist. 1, the protector is non-responsive or there is no protector. 2, to prevent the trust from needing a court-appointed trustee. 3, to save the assets from companies or threat of legal entanglement if the current trustee remains. And then you got 4, the grantor becomes involved in removing a trustee if there is no other trustee or the current remaining trustee is unresponsive or part of the trouble. The grantor may then appoint a new trustee with the approval of no less than 1/3 of the trust certificate holders, based on the number of TCUs each holds. 2/3 must approve if any of the trust certificate holders oppose appointing the new trustee. M, counseling trust members. The protector is the natural counselor and mediator should any disputes arise between the members of the trust. N, investigation of trustee activities. 1, inform the protector by giving him or her copies of relevant or periodic minutes. 2, any trust certificate holder or beneficiary may ask for an investigation into a trustee's conduct and behavior only as it relates to the trust. The protector may ask support from the certificate holders in examining any of the trustee's activities. 3, he or she may ask the Board of Trustees and other suitable advisors to review circumstances and evidence or to report to him or her any events about the investigation. 4, the protector may receive any information or documentation of any transaction, correspondence, or any other dealings of the trust. Okay.
All right. Oddly, though, sometimes the most troubling situations come from grantors in their old age. Some may lose their focus in the intent of the trusts. Sometimes they fire protectors for no reason at all. Not thinking, now they hire friends. Thoroughly incompetent to fire a trustee because of the ignorance of the newly hired protectors. This causes significant and trying troubles with the trusts. To prevent this, we suggest putting into the trust indenture definite requirements and standards for the trust protector. To further deter a grantor from acting against competent trustees, the trust protector may be required to have any of the following handled prior to being able to fire a trustee. 1. The support of one other trustee. 2. The support of 2/3 of the trust certificate holders. A. By number of units, or B. By number of holders. 3. Documented evidence of the breach of the indenture. For a thorough treatment on the trust protector's duties and dangers inherent, we suggest reading an article on the internet posted by the law firm of Bove and Langa, PC. It specializes in trusts and estates. Also, please refer to Table A, Relationships, found in Chapter 4, Building Blocks of the Future. This chapter is about trust structuring and outlines the protector's relationship matrix in the trust. Do you want to read anything, Dawn, before I continue? There was a little 72 there.
No, it's just it's talking about Peter Protector and Trust Neverland, the real story of the Trust Protector. So it's just a little note about a book he's referring to.
Okay. All right. Continuing. Experience. A professional trust protector wrote the following. He is a lawyer who has turned mediator. We have found he has exceptional abilities to get people with different points of view to work together for the same objectives. We asked him to share his philosophy of mediation, to let people know how he performs and why he is so interested in the entire field of dispute resolution. The following are his words. Trust protector and mediation skills. Did I miss something? No. Okay. Introduction. Long before a protector needs to terminate a trustee for violation of the trust indenture, use meetings and mediation to resolve conflicts. Disputes. It would be ideal if human relationship would be smooth, cooperative, and harmonious. I guess we would have to remove the human from that sentence if we wanted to achieve the ideal. The fact is, disputes arise in every area of human life. What dispute? It may sound silly to say, but the first step is to recognize that a dispute is going on. Sometimes it is not so simple to see, because just about everybody in the world acts with both open and hidden agendas. Mediator first, lawyer last. That said, what might be the next step to take after the dispute is identified? There are many answers to this question. One of them is, when the dispute is already lawsuit threatening or already in litigation, find and hire a professional neutral, like a mediator, to help nip it in the bud. This would be a good place to start to settle differences before both sides of a dispute telephone their attorneys, unless, of course, the lawyers recommend mediation to their clients. Definite cost savings. Mediation is much more often than not a successful way to resolve disputes. It is a cost-effective way to avoid lengthy, emotion, and energy-draining lawsuits. The real deal. I've been a professional neutral for 8 years. I'd like to share a story with you to show how mediation can work. Damage control. An art dealer who spends much of her time traveling throughout the southwestern United States to locate and buy original oil paintings from the area sold one of them to a first-time customer. The customer's personal check came back from the art dealer's bank marked NSF. When she finally reached the customer on the phone, he told her he did not want the painting after all. A week later, the painting came back, damaged, to the art dealer. Absolutely not. Both sides were stubborn in their positions when the case came to me for mediation. The art dealer demanded the difference between the original sale price and what she eventually sold the painting for, plus the cost to repair it. The customer said this was not Southwest art. He did not want it, and he owed her no money. Oops. Well, maybe. My first job as mediator was to see if the parties could agree on something. I had the art dealer show the customer the bills she paid to repair the painting. This prompted the customer to agree to pay the sum. Profits and the cost of litigation. I then took the art dealer and her attorney into another room and asked them how much she had paid for the painting. It turns out she made a profit on the completed second sale. She thought she was entitled to get and keep the higher profit from the first customer. I explained to her about the risks of litigation and the cost of trial. How it works is this. There is no way of knowing how a trial will come out. Win, lose, or draw. Also, much of the time when a party to a lawsuit pays for expert witnesses and pays attorney's fees and other costs, then even a victory will seem negligible. In other words, the odds are never good that any party will be put back in the place he or she was before the problem began, in terms of dollars and emotions. Let's wrap it up. I suggest that any added money the customer was willing to pay in this negotiation would come to her cost and risk-free. She and her attorney then allowed me to get the best offer I could get from the customer. A few trips back and forth between rooms resulted in a full settlement. Do I have a choice? Not everyone knows the ins and outs of mediation and arbitration. For example, most people don't know that they can hire a professional mediator long before they need to hire an attorney to handle a dispute. In fact, it is to everyone's advantage to do so. Since it is difficult to get through life without confrontation, one of the best assets one can have is a knowledge of when to use a mediator and when to call a lawyer. The general rule, call a mediator first. How I got into this. After practicing law in a conventional way for some 25 years, I came to realize the courts, while fair and just in some ways, produce stress for everyone involved. That would include the parties to a lawsuit, the attorneys, the staff in the law offices, the judges and the court staff, and just about everyone else who has anything to do with courts. I spent the next 10 years giving lectures and writing articles about alternatives to take disputes to court. I found my home. This led me to do the work that makes me most happy and most effective, helping people resolve their disputes. It is called, quote, alternate dispute resolution, close quote, which includes arbitration and mediation. The primary idea is to get people to the table sooner rather than later, reduce the cost of having the dispute resolved, and getting the problems behind them. I love feeling satisfaction when I see the pressure come off folks when their disputes get resolved. That's my work, and that's my passion. My wish. I wish a life. Oh, that's weird. That's a little feedback there. Okay, let me try that again. I wish a life free from disputes for every person who reads this. If a dispute does arise, consider mediation as a simpler and quicker way to resolution. Although this is the experience of a professional in mediation, one does not need to be a professional to be a trust protector. If the trust protector cannot resolve a disagreement, a professional mediator can always be called.
Okay, I just want to jump in here real quick. So does anybody have anything, questions or anything that they want to bring up?
Yes.
Go for it, Judy.
I was a professional mediator, 25 years ago or 20, I don't know. I went to training because in Wisconsin, they made a 2-hour mediation meeting requirement for divorce and family court disputes, right? So I was just thinking how this was written, that there was already almost, 90% of the time there was already a dispute. It was known to be a dispute. They had to come in. I think they had to come if they had a dispute. So 100% of them had a dispute. But now they're talking about in these trust meetings, if a dispute is identified, it's like the first thing is to identify that there's a dispute. And I think that's an interesting concept, because how do you do that? You feel like somebody's unhappy, and then does the trust protector then say, well, is there a problem here? How would you identify the dispute, that there is a dispute that needs attention? I guess somebody could threaten a lawsuit or something, but it's an interesting question.
There would be probably like disagreements. The easiest disputes are the ones where, they're having a balls out, like shouting war. That's obviously a dispute. Those are the ones where they say, if you're writing the minutes on that, keep the notes like short. Don't put any emotion into it. Don't say someone was screaming, all that kind of stuff. But someone from the outside looking in can go, okay, this got kind of heated. So now we need to take these two people to the side and say, okay, we need to come to a compromise or an agreement or something. We just want to make sure both of you, even though you had your little screaming match, that you're both okay, that you both feel, do you need to communicate more to get your frustrations? Like, what are the frustrations? And then if it's really outlandish, or, they both have a really good point, then maybe bring a mediator in at that point.
Well, I think that there's not always such an obvious, obviously dispute, but it's where like it could be put in the minutes, like so-and-so wanted to do this and so-and-so had a different opinion, or, there could be subtle ways to record the growing difference in the minutes. I think, that would be evidence that there's a problem arising,
Yeah. And it does say, like, if there's a disagreement, definitely write it down, but don't put any motion. Don't, like, whoever's writing the minutes, don't sit there and take one side over another, and don't put any emotion into the notes. Just give just the facts, just the facts.
And that was my role as a mediator. I was not ever supposed to side with one party or the other. And if I did, I caught heck from the other party, or they'd go and rat me out or something. But the other thing I wanted to say was, they talk about an attorney. This person that wrote this was an attorney who went into mediation. What happened in the field that I was in was all non-attorneys doing this mediation for families. And then the bar decided that it was a good area to get into. And so they kind of took over the mediation area. And that was pretty disturbing, because they have a very legalistic approach to mediation. Yep. Just my 2 cents from experience. Oh.
So the things that I noticed in what SR was reading was, there was a couple of things, bullet points, that I wanted to kind of mention. And that is that it seems like it's really, really vital that when you do a trust indenture, you think 10 steps ahead. Like, you have to almost anticipate these problems before they even happen, to really be able to, like, when the grantor is no longer there, the trust indenture can be like the grantor's voice and really cover their butts to make that trust last, like, on a generational kind of status. And it's literally like creating a company when you're building a trust, because you're trying to not only think ahead, but you're trying to put people in place that will be able to calmly and rationally handle these situations, which the trust protector is a big asset when it comes to that. And making sure that that protector, even if that protector, say, has to leave, okay, what are the requirements for a new protector to come in? What should the trustees be looking for? And what should they not be looking for? Like, you can't have, you can't hire your cousin or your nephew or your daughter or son to be a protector if you're related to them, because they really can have no kind of personal connection to the trustees, because sometimes these protectors are there to protect the trust, not to protect a trustee per se, but to protect the actual trust. And and then with the mediator. So go ahead.
I was going to say that it seems like the most important quality they should have is diplomat or diplomacy.
Be a really good diplomat. Yeah.
Calm demeanor.
And then with the whole, get a mediator, don't go to court. That comes into play because of the fact that the moment you bring law into it, the moment you bring the courts into it, that's when that private trust now becomes public. So they're really trying to make a point here to say you have to go through. That's why it's so important to know what is private and what is public, and to be able to separate the two, because the moment you bring a private trust in the public, you've now opened it up to scrutiny by government, by courts, by all these people that you're supposed to be keeping out. So it's really important to get that mediator in to help you make these decisions.
Yeah, and that's fine but a lot of times if you hire a mediator who's also a bar member, they can
well, yeah, that would be one thing that I would say you would probably have to put into your trust indenture. Make sure that the mediator is not connected to the bar in any way.
Even if it is connected to the bar, you can still have provisions where his bar card has no merit in the proceedings that are deemed private. So yes, it should be in the trust indenture, which can stipulate anybody that comes in to mediate, even a judge in chambers, would not make it public. So it depends on how the indenture is structured with regards to problems and resolutions. Because if the trust inherently is a foreign trust, the court, as far as its administrative capacity, because they're not Article 3 courts, would be barred anyway. So it depends on how the trust was structured, what jurisdiction it is in, determines whoever is going to do the mediating, whether it be public or private. And generally, if it's structured right, it would be private, because that's the whole intent of trust for the most part. I
have a question. Couldn't you also, in that trust indenture, put in where everybody would have to sign a, I think it's called NDA? Yeah, where now you're kind of saying, okay, I can't really talk to anybody about this stuff. Just a thought.
Most definitely.
Yeah, that definitely saves the trust's butt. And that way, if anyone does blab, you can go after them and still keep the trust private. Anybody else? Okay. SR, are you good to continue on?
Yep, I'm good.
Okay.
All right. High-end professionals. We suggest, though, that trust protectors be of professional caliber when there is a need to settle a serious dispute. One skilled in legal, accounting, and mediation matters can help. Trust protectors can be law firms as well as professional accounting organizations. We can also recommend a close family member who has enough business experience to be effective should the going get rough. Although the trust protector is rarely needed when this critical ability is called on, he or she steps in as an effective final authority. Often, just the mere threat of calling the trust protector does an effective job of curbing any strange behavior. Qualifications. The list below represents the ideal background of a trust protector. Bullet point. More than 10 years of experience. Bullet point. Negotiation mediation skills. Bullet point. Able to read legal documents such as contracts. Bullet point. Good writing skills. Bullet point. Organized and responsive. Bullet point. Flexible schedule. Bullet point. Easily reachable by phone. Bullet point. Preferably located in the same general area as the trust. Bullet point. Duties and obligations. Tell the protector about the specifics of the beneficiaries and your wishes. It can be that you have a troubled child, but no intent of ever separating the child from the trust group. Other members may often complain, and the protector responds to find a solution. The solution, though, is to include, not exclude, the child. To keep the protector up to date, he or she should receive periodic copies of trust minutes and attend a Board of Trustees meeting once or twice a year. Invite the protector to join in pending disruptive matters. Becoming involved in the early stages may avert a problem. Details to know. For this example, the protector is a lawyer. Usually he or she will have little to do other than to keep occasionally up with a general hum of the routine, trust business. Involvement in details is not necessary. When a protector becomes involved within a trust group, that person needs to have some or all of the following information. Bullet point. Legal name of the trust and a copy of the trust indenture. Bullet point. Background information on key family members. Bullet point. Red flags such as addictions, tempers, tendency to lie, criminal behavior, and, of course, the knowledge of any talents of those involved in the trust. Bullet point. Trustees' backgrounds and why they were chosen. Bullet point. Financial report and banking locations. Because the trust protector can remove a trustee, he or she may need to go to the bank to remove a trustee from the checking account. Bullet point. The time and date of the next Board of Trustees meeting so he or she can meet the board members. Bullet point. The grantor's priorities and expectations. Fees, retainers, and compensation. In the collective...
Just a comment about the trust protector. Sounds like it's somewhere between a guardian angel and a sergeant at arms.
All right. Fees, retainers, and compensation. In the collective experience of many who have contributed to the art of passing the buck, the trust protector intervention has happened only a couple of times. In one case, it was tricky, as an exchange became vicious, and in the other case, mediation resolved the problem. Because the odds are against using a protector, We found that an annual retainer covering 1 hour of time works efficiently after the initial setup of the trust. This is because when a trust protector acts for several trusts, most of them never need the service. This 1 hour of time for each trust equals an upfront fee for doing little to nothing. Although it is likely the protector spends 1 hour in a Board of Trustees meeting. Should there be serious concern if the grantor wants to fire the trustees, then the grantor directly pays the protector. Otherwise, there is a conflict of interest. Billing, though, is by trust. Any services over the 1 hour are paid by the trust needing the support or by the grantor if there is a dispute with the trustees. Settling disputes. Involve the trust protector if pending litigation threatens the trust. He or she should interview all parties. The objective is to avoid the courts. Privacy is not guarded when trust documents become public and get filed as part of litigation. If the trust protector is not a lawyer, or the trust protector feels unqualified, then involve the protector in getting a lawyer. Should the dispute be between the grantor and the trustees, the trust protector's highest priority is to protect the trust and its beneficiaries. Dismissal of a trustee. This is no small matter. The trustee may have risked the privacy, financial stability of the trust, or has shown himself or herself to be untrustworthy and cannot, thus, continue to work in the capacity of trustee. Compromised. In just about all cases, trustees resign when compromised.
Hold on. There's a appendix there.
Yep.
Okay, hold on. I need to bookmark this so I can come back to it. Okay, we have A4. It's so funny how when they were talking about sometimes even the mere mention of calling in the protector settles everyone down. And it's like, don't you guys make me call the protector. Like, don't you make me call dad because I'll bring him in here. Y'all will get a whipping.
All right.
Okay, so we have a format 4. This is resignation. What was that, Judy?
That's what I meant. That's what I meant about the sergeant at arms. It sounds like, oh, we're going to call in the military here, the police, whatever.
Exactly. Okay, so after reviewing many trust indentures, we have found, in general, the protocols for resignations often are less than satisfactory to the moment. A resignation is uneasy, even if it is voluntary, and there are no loose ends to financial matters. For example, see the registration letters, sample format 15 and 16. Time for transition. The transition from one trustee mandates updating many financial and banking documents and often can take weeks to make a full chart or change. Couple this with other Board of Trustee members getting to know the new trustee, and there are likely glitches. This particular excerpt was chosen because it seems thorough, not that it covers every detail, but it provides solid information about what to do. After all, an indenture records the grantor's wishes, and here they seem clear. Financial responsibility. When a person who has a financial responsibility leaves a trust, many details often need to be wrapped up. In this format, several steps are given to assure the Board of Trustees that matters have been properly handled. The ideal is for the resigning trustee to take the new trustee to the bank before departing. The friendly introduction to whomever the parting trustee most often deals assures the bank of the solidity and formality of the trust group. Giving a copy of his or her resignation directly to the bank personnel assuages any uncertainties. You will be surprised how many times you need to copy the resignation to prove the overlapping dates and timelessness of the replacement of trustees. Number 1, trustee resignation. A, any trustee, co-trustee, or successor trustee may resign without permission of the court and without prior judicial accounting unless the Board of Trustees demands the accounting. B, the resigning trustee gives either a verbal or written status of his or her trustee duties, so the trust may carry on without undue interpretation. Or, no. Interruption. C, the resigning trustee must present a letter of resignation including 1, to whom the notice is addressed, 2, the name of the trust, and 3, the resigning trustee's position, 4, any specific reason for the resignation, 5, acknowledgement of a successor's taking his or her place, 6, information how to reach the resigning trustee, 7, the date of resignation, not fewer than 10 days after giving such notice when such resignation becomes effective. 8, if the trustee signs financial documents, instruments, and banking papers, then notarize the resignation, although the banks may or may not need it as they have the resigning officer's signature on file. 9, if the trustee does not sign financial documents, the receipt by the executive secretary is enough. 10, the Board of Trustees can refuse to accept the resignation for specific reasons listed within Board of Trustees minutes or by a formal letter to the resigning trustee. D, the resigning trustees delivers the notarized resignation to at least one other trustee or the executive secretary. Either the trustee or executive secretary signs an acknowledgement of receipt. E, the resigning trustee or co-trustee remains liable until the delivery of the status report and the accounting, if so requested by the Board of Trustees, and acceptance of the resignation. F, keep the letter of resignation in the trust records. Trustees may show the resignation to confirm to third parties who have a valid need to know the status of the current trustees. G, if a trustee leaves without a letter of resignation, then enter the last date of performance by the trustee into the minutes. One of the officers writes a statement of resignation for the trust protector to sign and get notarized. Without the letter of resignation, though, the trustee remains liable until the trust protector signs the resignation. Okay, so that was format 4, but I want to, wait, formats 15 and 16. Is there a 15 and 16? I kind of wanted to read that 15 and 16, but I don't know where they're talking about. So back to you, SR.
Okay. Compromised. In just about all cases, trustees resign when compromised. The problem, though, becomes much greater when there is a major financial consideration. In larger trusts, trustees can earn upwards of $500,000 a year. In this case, they may fight to keep their position. The trustee can hire a lawyer to defend him or herself. This becomes messy business and again involves the courts, which should be avoided. Signature. The easiest way to stop the power of a trustee is to remove the trustee's signature from all trust financial accounts, making said trustee powerless to conduct business neutralizes that person. We showed a bank's legal department the trust paperwork allowing the protector to remove a trustee. It recognized the documents, gave the protector the authority. The legal department, though, is uncomfortable with the prospect of getting involved and hopes the paperwork is never used.
Okay. We've got another Appendix A3, but we already read that one, so keep going.
Procedure. Accusations will not cause termination of any trustee. There needs to be enough investigation and documentation to build a solid case. It is not uncommon for beneficiaries to be upset with the actions of the trustees. Beneficiaries, not privy to the myriad financial details of the trust finances, have incomplete information. Keeping this in mind, the trust protector is likely to believe the trustee first, the beneficiary second, and work toward better communication. Should the allegations be initially or eventually be justified, the trust protector needs documentation and before taking any action should have researched the causes. Before termination, mail a certified letter to the errant trustee advising him or her of complaints. Enough time to respond is part of any formal termination effort. At this point, though, an errant trustee usually resigns before further action is required. Replacement and training. As the trust matures, the intricate details become great. Bringing in a new protector requires him or her to learn the trust procedures and its history. The easiest way to do this is to have the trust protector read the minutes of previous meetings and attend the next Board of Trustees meeting. Removal of a protector. The grantor can always remove the protector. After the grantor passes, though, one solution is to require agreement of 2/3 of the beneficiaries to replace him or her for cause. That is, this cannot be just a whim. Circumstances set in the trust indenture allow replacing a protector by the Board of Trustees after the grantor has passed. This can be on the death or resignation of the protector, or the protector's failing health under conditions set in the trust indenture. For example, if the Board of Trustees requests statements from 2 medical doctors about the protector's health, and he or she fails to do so, then the Board of Trustees can replace the protector. Replacement of trustees. The protector has the authority to replace the trustees if they have quit or suddenly died. As explained in the trust indenture, this authority applies only if both trustees are absent. If one trustee remains, he or she can always hire another trustee. Court-appointed trustees. The protector's main purpose is to avoid court intervention. Authority given to the protector requires him or her to act. If the protector does nothing, then the trust comes under the jurisdiction of a court, as the cash flow stops for failure of trustee signatures. Imagine what happens if a trust with a $20,000 a month cash flow is unable to pay bills and send out distribution checks. Separate agreement. Although the authority for the protector to act is in the trust indenture, the trust indenture is a private document. Create a separate agreement to show to others for both the grantor and the protector to sign. When dealing with financial institutions, they only need to know what the protector can do about removing a trustee. A concise, one-page summary is enough. Organizations contributing to this section have learned the protector role is integral to the smooth functioning of the trust. A statement about the protectors having the authority to terminate a trustee is simple. Yet the complexity includes several steps and formal notice. The legal departments of financial institutions need solid evidence presented to them. The one-page statement outlines the protector's authorities. The financial institution may need specific types of assurances before responding. Information resource. The Internet has several articles about trust protectors should you want to research this subject further. And I am done.
Thank you very, very much.
You're welcome.
Okay, so now we are on chapter 12. Let me bookmark this. What was that, Judy?
Interesting title to chapter 12.
Ah, yes. Screwball Trusts. Okay, so Justin, did you want to read?
I can. Sure.
You want to give it a go?
Yeah, if you want me to, you want me to start on chapter 12?
Yes, please, if you wouldn't mind. Again, I'll read the appendix. I'll keep an eye out for those.
All right, so you just want me to stop every time I see an appendix?
Yeah, and either that or I will give you a heads up.
All
but
right.
I don't think, doesn't look like this one. Yeah, there's some of the little footnotes might need to be read, but it doesn't look like there's actually any appendix readings, but there are some readings. So I'll just give you a heads up.
Fair enough. All right, chapter 12, Screwball Trusts. When it comes to trusts, lack of education can be heartbreaking. Although this chapter focuses on the misuse of the common law trust, statutory trusts can be equally faulty. You might ask yourself if these people who lost to the IRS were guilty of fraud or guilty of not knowing enough about trust structuring to know how to handle accounting. Being ill-advised is obvious, but not investigating further and reading court cases is their responsibility. The scam. Trust promoter is often ignorant of his or her own errors. Mixed up with trusts are the controversies about taxing. Some believe trusts hold a key to avoid the IRS. Knowledge and skilled administration make a trust successful. The cases presented here display the lack of correction information. We summarized 5 cases, leaving the more legally inclined to get all the details from the sites given. One of those reports reveals a clever scheme, and others are simply sad. They show a tangled understanding of trust. This results in an improper application of basic trust principles. Before we delve into the details of scam trusts, the IRS provides a fair description of misused common law trusts. The grantor assigned earnings to the trust. We discussed the issue of W-2 wages in Volume 1, Chapter 8. Revenue Ruling 75-257, Family Estate Trust. Grantor as owner, lifetime services to the trust are taxable. Grantor held 100% of the units of beneficial interest therein with himself, his spouse, and a third party as trustee. Grantor is considered the owner of the trust under Section 674.76 or 676 and 677 of the Code. Third party trustee who has no beneficial interest in the family estate is not an adverse party. The grantor's wife, as trustee, has no direct beneficial interest in the family estate and therefore is also a non-adverse party. Wages assigned to the trust for lifetime services were taxable. All right, there's your 76. You want me to keep going?
Yep, keep going.
All right. This is a grantor trust. It is as though the grantor kept all the assets in his own name, This is the basic format of a living trust. The Laverne Schultz and Barbara Schultz Trust. I'm going to keep going. A particular trust company claiming to create constitutional irrevocable trust had its trust examined by the IRS. Several customers came under the audit microscope. In a preliminary letter sent to the unhappy recipients, the IRS listed several recent court cases in which the hapless trust grantor paid back taxes because the trust failed the irrevocable trust test. Oddly enough, court cases like this one allowed us to discover the proper structure for such trusts. Because the trustee lacked power to control the wage earner's employment and the non-adverse trustee had unconstrained power over the trust assets, the trust sold to the Schultzes as an irrevocable trust became a judge-grantor revocable trust. Thus, all taxes not paid before now became due. Personal consumption. The Schultz Trust took deductions for personal consumption, expenditures, food, clothing, travel, education, and entertainment. Under the IRC, trust expenses are only deductible if they are somehow inextricably linked to the producing income. In other words, clothing is deductible if it is a needed uniform, education if it is about the trust business. So what could the trust grantors have done to avoid this unfortunate circumstance? And where did these petitioners go off track? Does the IRS carefully explain what they should do? Obviously not. The IRS is in the business of collecting taxes, not educating people about tax avoidance. First, the constitutional trust is no different under the law than any other irrevocable trust. A trust is a trust and must be managed as a trust, not as a personal checking account. The courts are not interested in the trust classification. What matters is the substance of the transaction. If a person claims to have an irrevocable trust, the trust must perform as one. The goods inside a trust are separate from one's personal belongings, as the trust assets are for the beneficiaries. If Laverne and Barbara Schultz had taken a wage from the trust and put the money into personal checking accounts, the funds would then have been separate for their personal purchases. No beneficiary distribution. Another point the commissioner makes about the Schultz Trust is there is no beneficial distribution. Here's where most bogus trusts fail. An irrevocable trust is an income-producing business with profits distributed to the beneficiaries. If they use trust funds for their children, all they needed to do was add them up at the end of the year and give a K1 to their children. It is not likely much tax is due. Just pay it. Failure to do this means it is not a trust. The Schultzes put their earnings through the trust. The trust did not produce its own cash flow under a board of trustees. For example, if the trust was funded by exchanging assets or money, such as with a mutual fund, then the cash flow of the investments belong to the trust under the control of the board of trustees.
All right, hang on first. Hold on. So I just want to make sure that we all understood that. So they were claiming that it was a common law trust, but they were operating it as if it was a revocable trust due to the fact that they were not separating private from public. So I believe they said that because they were getting paid through the trust, were they putting that money back into the bank account for the trust? They weren't putting it into their own personal bank account? Is that what they were saying?
To me, like they were taking it from the trust and putting it in their own account, like a paycheck.
So, okay, so hold on. The Constitutional Trust is no different under the law than any irrevocable trust. A trust is a trust, must be managed not as a personal checking account. The courts are not interested in the trust classification, but matters in substance. Person claims irrevocable, and the trust must perform as one. The goods inside a trust are separate from one's personal belongings. So it seems as if they did not set up like a business banking account, correct? They were just putting all the money into a personal checking account. So it says if Laverne and Barbara Schultz had taken a wage from the trust and put the money into a personal checking accounts, the funds would then have been separate for their personal purchases.
If you're making an income collecting it from as a wage from the trust.
I'm just trying to figure out.
Through the cases, that's what made it taxable, because they were collecting a wage or an income from the trust to their personal uses.
Oh, so they were saying, no, I don't need to pay the tax on it because it's coming from a trust. But you're like, no, because it's a paycheck that you're being paid from the trust. So you need to pay taxes because it's not a hidden or a pass-through accounting. It's actually the trust is paying you for a job, which you are then putting into a personal banking account. So you need to pay for that, the tax on that, which technically shouldn't be a whole bunch.
Yeah, I think that's right. Like basically, if you have a trust and you want anything, everything goes to the trust, and the trust holds everything. You're just able to use it.
Okay. Yeah, I think that they were thinking that they didn't have to pay tax on it because it came through the trust. And so and they were thinking that, oh, it's money that I can get for free, as opposed to, no, that's money that you're getting from a trust that is free of tax, or at least shielded from a majority of tax. But once it leaves the trust account, it becomes taxable.
Because it's always, if it's leaving the account, it's always either purchasing something or paying someone for services.
Yeah. Okay. Is that what everybody else understood? Nobody had any other questions? Okay. All right. Go for it.
Right. Let me continue.
Yeah.
No adverse party. All right. No adverse party. The next point of failure was that both Mr. and Mrs. Schultz were not only the trust grantors, but also the trustees, and there was no adverse party. We defined substantial adverse interest and adverse party in Volume 1, Chapter 13. Order passing, the sad plight of the home and estate. You want to? No, okay.
Wait, where are you at right now?
Page 130 on the book. The sad plight of the home and estate.
Thank you.
Just a case law. Just case law citation there.
Yeah, I scrolled down to the bottom to see what that citation was.
Oh yeah, sorry. Yeah, you continue. The next page will definitely stop, but this page, keep going.
All right. Sad plight of the home and estate. During the mid-1970s, Dr. Bruce Holman and his wife bought what they thought was a secure, irrevocable family trust. Through later legal complications, they discovered it to be revocable and liable for the income taxes they hoped to avoid. In examining this case, we find several common misconceptions and inaccurate arguments used by those who do not fully understand the use and purpose of an irrevocable trust. Adverse party. The first complaint was that both Dr. and Ms. Holman exercised control over the trust without the existence of an adverse party. The Holmans also appointed Ms. Holman's mother, Addie Duncan, as a third trustee. Being blood related, she did not qualify as an adverse party. No business deduction here. The next issue, and probably the red flag that started the complications for the Holmans, is that they took the cost of setting up their trust as a business deduction. The cost of setting up a trust is a personal expense and not a write-off. The trust then became subject to an audit, and taxes were due, which the Holmans paid. Control. Next, the Holmans sued to get their refund of paid taxes. They claimed their family trust was legitimate, and the IRS had no right to tax them. This, of course, was their next mistake. It brought their trust under more severe scrutiny. According to the trust indenture, the trustee controlled the trust finances. This would have worked to their favor had there been an adverse party. The Holmans were the grantors and used the trust for their own gain, having complete control over all the finances and assets. Because they became the trustees, no irrevocable trust existed, exactly the same as in a living trust. If, as demonstrated in Volume 1 with Miss Betts and the Holmans, with Miss Betts, the Holmans had not used any of the trust money for themselves and only managed the funds for the beneficiaries, they might not have lost their case. The kids are beneficiaries. The Holmans named their children beneficiaries. The parents, acting as trustees, though, did not give them K1.
All right, hang on for a second. Okay, so in the Holmans case is they made themselves trustees, and then they made the third trustee the wife's mom. So there's no adverse party. And so it's more like a statutory trust or something at that point, or maybe it's just revocable. And so what their issue was the setting up and the parties that they put in play as chess pieces in the trust, in their trust, was set up all wrong. And had they had someone from the outside, like a friend become a trustee, they would be the adverse trustee. And so the Holmans named their children beneficiaries. The parents, acting as trustees, though, did not give them a K1. And that's something that keeps coming up over and over and over again, is this K1. So if you have a trust and you're a beneficiary and you're not giving somebody a K1 report to go along with their 1040, that's going to throw up a red flag to the IRS. And that footnote says the same form is used for various other legal entities, e.g., for example, to pass funds from an organization to a person or from one organization to another. Okay, and go ahead, and then after you've finished that grantor trust rules, blah, 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 there's another footnote.
All right.
So there was no
evidence, substance of transaction. This trust was used for the children. The court ruled the plaintiff's attempt to create a trust was merely an anticipatory assignment of income. What is it? Fix it.
Anticipatory.
Anticipatory assignment of income, which would not shift the incidence of taxation from plaintiffs to the trustee. Second, the district court relied on the grantor trust rules of 26 USC substatute 671 to 679, 1976.
So that's
81 to decide the Holmans were properly taxed on the income. All right, go ahead.
Okay, so that 26 USC states the grantor is taxed based on his or her dominion and control over the trustee, and whether or not there is an adverse party. In other words, if the grantor does not control the trustee, he or she is not taxed on the assets. Go for it.
Okay, so you got to give the control over to
Oh,
somebody
and then
else.
yeah, exactly. Then you have to have that adverse party as a trustee, and that adverse party has to have more TCUs, like has to have more control over the trust than the grantor. Because if it doesn't, and the grantor still has more power, more voting power, whatever, then it also does not qualify as a what do you call it, trust, an irrevocable.
Irrevocable. Okay, so whoever holds the most assets holds the most liability.
Correct. And that keeps it separate, because the grantor can't have control over the trust. It has to appoint someone who it's not related to have the most control in the trust. So you can set up your wife or your sister and your brother-in-law as a trustee, but you have to have an outward source, a friend, a colleague, or whatever, be the trustee as well. And then they become the adverse party. And then that person also has to hold the most trust certificate units, because now their power is above the grantor's power, and above the grantor's relatives' power, and above the beneficiary's power. So, and that solidifies it as a irrevocable trust that, is if you put everybody else in play that's smart and knows how to keep the government out, then, the IRS can't come after the trust. Because if it walks like an irrevocable trust and it talks like an irrevocable trust, then it's an irrevocable trust.
All right, we got the U.S. versus Schmidt and the next little title coming up. You want to look that thing up? The case number?
No, well, we don't know. But we will read about the W-2 wage thing. So, but you can finish the page.
All right. And then he went to jail. In 1986, Lonnie Schmidt sold a domestic trust known as an unincorporated business organization, UBO footnote 83, using an offshore entity as beneficiary. Mr. Schmidt told people, although there was a trustee in the Marshall Islands, the individual buying the trust had total control. Mr. Schmidt's salespeople explained to the potential buyers they could pay whatever taxes they wanted to pay. The greatest error was the buyer named himself or herself the trustee of his own UBO. Further, Mr. Schmidt's sales representative told potential clients that all earnings, including W-2 wages, could be transferred into the UBO.
Okay, so it says W-2 wages cannot be given to the trustee because the wage earner, not the trustee, has complete control over the cash flow. For a trustee to be legitimate, the cash flow must go directly into the trust without the grantor or any exchanger's participation.
Yeah, so that's why you put the trustee, is for them to make the investments in, right?
Well, the exchanger is just somebody who adds, I guess, puts the corpus into the trust, or any corpus into the trust. But it's got to go into the trust. And a W-2 cannot be given to the trustee because the wage earner, not the trustee, has complete control over the cash flow.
Yeah, I get that. because it's a trust is basically it's supposed to be private if it's irrevocable.
Yeah.
So
Right.
when you start putting tax forms in it, it's not private anymore.
Correct. Yes. Now, K1 reports can be done. I think it's like the 1040s and the K1s. That's what you would give.
And like the
K1
7
isn't a K1 a distribution?
Yeah, it's like whatever. I think it's what they've been given, the assets or money from the assets.
So it's considered income then
K1.
if it's distribution or let's see. I think it's
Yes, K1s are given for distribution.
Yeah, so it's to report income, losses, dividends for business partners, S Corp shareholders, investors. So it's like we talked about that on Friday, how they put like $22,000 in stocks, but when they cashed it out, it only came out to be $7,000, and the IRS was like, "Well, wait a second, we want taxes on the $22,000." They're like, "No, you can't have it because though they put the money in, they only got back $7,000." And so it was through the K1 that they were able to prove that they only got $7,000 from it, and which is what they could, because they liquidated that stock.
So the trust never takes the loss. Then it's distributed to
The beneficiaries. Yeah.
Okay. With the exchanger, if I remember correctly, the exchanger, when they put their whatever assets into the corpus, they're actually getting a percentage of those certificates.
TCU,
if I'm not mistaken.
Yes. So they get a certificate for, so last reading, that dude, I can't remember, what was his name? Walter or something like that. He started one trust and put a bunch of, like, he put cash, property, and all that kind of stuff, but he created a separate trust for the property. So he got 2 certificates that equaled out to be, I think, about like, what was it, 65 TCUs total?
Right, but was he a grantor or an exchanger?
He was the grantor and exchanger because he added the corpus.
Right.
But we were trying to figure out, why did he get 2 certificates? It's because he created 2 trusts, and he put corpus into both of those trusts.
So he's holding 2 positions in 2 different trusts.
No, he was an exchanger and grantor in both of the trusts. So there was the family trust he created, and he was willing to put money, stock, and property. But he decided to create a separate trust for the property. So when he got his trust certificates, and because he started both of those, he's the grantor on both of those, but he is also an exchanger because he put corpus into both those trusts, which he got 2 different certificates. He got certificate 1 and certificate 2, and then which equaled out to be about 65 TCUs. But he hired a adverse party trustee, and he gave him 125 TCUs, which he wasn't related to the guy, which made him an adverse party. And he gave him more control, more percentage of the trust, which solidified the trust to be like unpenetrable. And that's what we read on Monday. Okay, so continue on.
All right. The no-name offshore beneficiary account. Schmidt advised the clients to name First Surety Bank an offshore entity in the Marshall Islands as the beneficiary, since it is not subject to U.S. tax jurisdiction. The bank refused inquiries from the IRS.
All right, hold it.
Footnote 85.
Hold it. The IRS can obtain any tax information from any country by extortion and bribery. So do not believe anyone who tells you that your records are safe anywhere. Recently, the IRS signed agreements with most of the offshore havens. Interesting. Yeah, the IRS is everywhere, man.
They're as big as the post office. It's ridiculous.
Yeah, which just goes to prove they are not a government entity. They are in a class unto themselves. They are a separate entity, a foreign entity that is within every single country. Just like every single country has a form of the birth certificate. And it's this whole one world order thing.
They're the biggest bookkeeping assembly in the world.
Yep. They're a total, what do you call it? Cartel. They're a total cartel.
Now, is the IRS a privately owned company also?
They're kind of like the henchmen for the Federal Reserve.
They are their own trust, I believe.
They're not a government entity, just like the Federal Reserve is not a government entity.
No, I understand that, but are they privately owned like the Federal Reserve is? You know what I mean?
Yes. But they're, like I said, I think they're an offshoot of the Federal Reserve. Like they're their henchmen. They're the ones that go and collect the interest on the money that they're giving everybody. Printing.
For the public anus.
Yeah. So the Treasury is governmental. The IRS is not. But the Treasury works with the IRS because they have to also get the interest that the Treasury is, they make a demand that they need so many dollars. So the Federal Reserve prints that money, gives it to them, to the Treasury with interest, and the IRS then works with the Treasury to collect that interest.
Those are the bonds, right? The Treasury issues bonds to get the money from the Federal Reserve System, if I'm not mistaken.
Right, and then we're surety for their debt,
Yeah.
which is why they come after us. Okay, continue.
All right. Each investor or grantor, now a trustee, signed a signature card for a numbered account at First Surety Bank. Every distribution from the trust went to the bank to become available for the owner trustee to withdraw, thus traveling a full circle with no true beneficiaries involved. The trustee used the funds for his or her own purposes. This closed loop pattern was proof positive the trust existed to evade taxes. The scheme came to the attention of the authorities with some owner trustee filed 1040s at the end of the year. They claimed refunds. Worse, they also filled out federal fiduciary returns listing income which did not, in fact, belong to the UBOs, and then claimed deductions to reduce drastically the taxes due. Even when the prosecution laid these details on the table, Mr. Shipman refused to quit. He moved to dismiss the indictment because it was based on alleged tax law violations which were vague and highly debatable, and that as a matter of law, the indictment was defective. Footnote 86.
Okay, it says Mr. Schmidt forgot the simple fact that the taxing agencies had more authority and power than he did, and that he who owns the gold owns the country.
His group moved to dismiss the indictment, asserting the prosecutorial misconduct during the grand jury review deprived them of their constitutional right to due process. Both motions were denied. Mr. Schmidt was convicted for conspiracy to defraud, U.S. Title 18, willful failure to file and aiding preparation of false returns obtained as a result of promoting trusts that were tax shams, used to hide income and assets fraudulently. This UBO became a criminal case. If the government had wished only to discover the taxes due, it would have filed a civil allegation. The judge pointed out that for more than 50 years, courts held that when placing assets in a trust, either the grantor must give up total dominion and control or pay the tax on the income. This case serves as a dramatic reminder that you are liable for taxes only on what you own, and that to dispose of legal challenges, you must surrender assets to a genuine board of trustees. Exclusive rights of lifetime services. There was a time when exclusive right of lifetime services was part of some common law trust indentures. This meant any money earned by the trust grantor belongs to the trust. Therefore, people assigned earnings to the trust. So everybody would just throw their money in the trust. That way they didn't own nothing. The tax court disagreed. It had said in many court cases that one who earns the money is the one who pays the taxes. What often happens in bogus trust schemes is the person who sells the trust advises those who put the funds into the trust to avert taxes by depositing personal money into the trust checking account, having control. If funds come into the trust from trust earnings, such as joint ventures, partnerships, stock portfolios, and rental income, there is no doubt the funds belong to the trust and not the grantor. If the grantor deposits funds into the trust, then he or she controls them. It is the same as giving money to children. Sorry. The parents control the money, not the children. Mr. Schmidt put his W-2 wages into the trust. He remained in control, as at any time he could decide to put his W-2 wages into the trust. As shown in Volume 1, Chapter 8, this does not work. Income producing source. In most states, a business can be put into a trust. In those states, though, it is important other income supplement the business venture, so the business is not the only cash flow source. This prevents the person running the business from controlling the trustees. As mentioned in Volume 1, Chapter 17, it is better to make the sole proprietorship a partner with the trust. Joint Foundation and Jack Malone. Jack Malone was the founder of Joy Foundation.
Hold on, Justin. Does anybody have any questions about what he just read or wants to comment on what he just read? Nope. Okay. All right. Sorry. Go ahead.
And I'm sorry, but do I sound all right? Can everybody understand me and everything all right?
Yep. Except it's schemes.
Am I bouncing in and out?
You're saying schemes in its schemes.
Tomato, tomato.
Right. No, but you're coming in perfect.
All right. I'm going to go on then. Jack Malone was founder of the Joy Foundation and sold trusts. He lost his battle with the IRS. A judgment was posted on his website as punishment for his misdeeds. The Joy Foundation client lists were confiscated. This announcement seems harsh, but there is more to this story than appears. Federal serfs. There is a difference between those who sell trusts and go to jail for tax evasion and those trust companies teaching proper trust structuring and administration. The beneficiaries pay the tax. The main focus of the trust is for the beneficiaries. Unfortunately, in the eyes of the IRS, trusts are all about the taxes, legality of the IRS. Where many constitutionally oriented trust companies go awry, is failing to understand that even though the IRS may not be legally established, it is bigger than them. It has an unlimited cache of Federal Reserve notes to chase those who try to divert its power. When a trust company tells people they do not need to pay taxes, then the IRS, the police for the Federal Reserve, gets irritated. The trust company becomes a target. The IRS brings it down with all its clients, as seen as referenced in as a reference website. Who has the power? Jack also told the federal income tax is unconstitutional as a direct tax, not a portion among the states. Jack is right. But who has enough power and especially money to go up against the IRS? If Big Bad Brother doesn't like what you say. Further, Jack said the Internal Revenue Service is not legally sanctioned to collect taxes, but he forgot. The judge pays income taxes. If that judge rules against the IRS, unpleasant complications in his or her life may follow. Your life is not worth a sacrifice. Simply put together a trust for the beneficiaries and conduct your life accordingly. Do not mix the politics of taxation with trust funds. The difference, personal and trust taxes. Jack was found guilty of advising people not to file their tax returns, giving false information, and interfering with the administration and enforcement of the Internal Revenue laws. Nowhere in the published default judgment is any statement about whether the trust filed or did not file or did not pay its taxes. So what was Jack telling people about how to manage their trust? Maybe nothing. Trust accounting, by the way, is atypical when compared with other types of accounting. The trust taxes are reported to the IRS on a Form 1041, which is different from a personal 1040. In fact, we have discovered that it takes substantial education learned through initiation into the trust world just to handle the accounting and the reporting. How should it have been? As usual, the judgment does not say anything about what Jack should have done. First, the taxes filed by the grantor are separate from the taxes filed by the trust. So if Jack sells trust, why did he advise clients about personal taxes? Okay, sorry. Why did he advise clients about personal taxes? This is like selling apples and telling people to eat oranges. One has nothing to do with the other. In fact, if you want your trust to be safe, you need to pay personal taxes. What better insurance a trust is set up correctly? Irrevocable trust support society through helping the family. Both the courts and the IRS discourage the selfish use of an irrevocable trust.
Okay, so I guess the 1040 is for beneficiaries to file with their K-1, and then the trust files a 1041.
So how are people going around selling trusts? I mean, I guess that sounds like a real scam scheme.
No, that's they were talking about that. I think in book 1 is they were doing all these offshore trusts. Oh, just do a trust, an offshore trust. You won't have to pay any taxes. It's a total shell game, blah, 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 blah. And they were getting away with it for a while until the IRS came down on them hardcore. And then everybody went to jail. I think it was like, what was it, in the 80s or something? Everybody started going to jail for all those shell corporations and stuff.
So they must have provided paperwork and all the setup for the trust. And with promises that you don't have to pay taxes.
I mean, look at what is it, Fearless Floyd? They're all talking about trust and how you don't have to pay taxes. And I think who else was doing it? Someone else is like, they're all out there claiming, oh, just put everything in trust, a foreign trust, and you won't have to pay taxes. And then you can, just use your money. And it's like, no. Like when I started reading this book, I'm starting to realize, no, that's not how it works at all. But that's how they sell it. And they think
it's just it's a form of a business. A trust is a business. You're running a business, it sounds like.
Yeah, I mean, putting it together, it's almost like you have to think of it as a company, like a corporation that you're putting together. You're employing people to take care of the business, to focus on keeping the business as private as possible, and to keep government out of it as much as possible. And so, it is like a business. It's absolutely a business. It's just a private business. But if you're the grantor, it's going to be kind of hard for you. That's why they keep saying over and over in this book, when you set these up, don't set it up for personal gain. You've got to be thinking of other people. You've got to be thinking of the beneficiaries. Now, that there are ways that, these trusts can help the entire family by creating multiple trusts, then you can kind of, rotate the money within the family. Keep it all in the family. But to think, okay, I'm just going to build a trust so I can have all of my money instead of giving it to the government and the IRS, that's not what trusts are for.
I have another question about, so this trust had a large amount of funds. Why do it this way versus like having a bank? You can get trust services, right, for somebody to manage it, but then you'd have to put your
that's more like statutory. That then you have a statutory trust, and that's when, if you're hiring lawyers, you're hiring bankers, you're hiring accountants. These are all people with governmental degrees per se that don't really give a crap about your trust and will do the minimal work, and they're not going to be getting a whole bunch of money unless, of course, you're doing a trust for the Rockefellers. So
also you have to put faith in them that they're doing the right thing, or that that they, you're losing a lot of control, I guess.
Right. And you've really, the whole thing is called a trust. You have to trust the people with your assets. So it's very, and it can't be all self-serving. So when you go into this, you really have to think about other people and helping other people with these assets. And in turn, the other benefit of putting things in the trust is putting a car in the trust, putting a home in the trust. Now the government can't come after you, or other people can't come after you for liability issues because it's protected by the trust. So really, it has more to do with protection of assets and helping others.
You want to keep going?
You're done, I believe.
Well, we've been 2 hours.
Next
now,
chapter is
right?
chapter 13, and we already hit 8 o'clock. So,
All right, cool.
You did good, Justin. You did good.
Thank
And
you. I was
thank you
worried about
guys.
that. I didn't know if I was reading too fast or messing up too much or what.
No. It's good practice too to like read out loud. I know by me reading multiple times, I've definitely gotten better. I don't even want to re-listen to myself on the first reading of the first volume. I know I was messing up a lot, but it really does help to read out loud.
You
I
think
agree
that
with that completely.
you think it soaks in when you're reading out loud versus listening to somebody else, or is it better to listen? As far as absorbing, I always find it's kind of hard when you're reading out loud to absorb
It is in the beginning, but I'm going to tell you, from all the readings that I've done, I've gotten way better at reading and absorbing by continually reading out loud. Because before, it was really hard. And I was kind of zooming through it. What was that first time? I think I zoomed through 5 chapters. I was like speed reading. Everyone's like, what the heck did we read about? So I was like, okay, maybe we should stop in between chapters, or maybe even in between breaks within the chapters to discuss what we just read, which makes it stick a lot more.
I've got in the habit now at the house is I'll read it normally once out, or not even out loud to myself. I'll read it through a book once, and then I'll turn my Adobe on and have it read it to me while I look through it, and I'll take notes as it reads it to me in my highlighter and stuff, and I can pause it and write the important parts down and stuff.
Yeah, if I'm taking the meticulous notes, I'm going like half time, half speed of what someone normally talks to take the notes and really have it sink in, especially if someone's talking really fast, like freaking some dude. Oh my God, he talks so fast. I literally have to slow him down half time.
Forrest, right. He does. Oh my gosh, you're right.
Yeah, and he throws out so much information. Like, it's good information. My brain can't compute that fast. And so...
Did you stop recording, by the way?
What was that?
Did you stop the recording?
No.
We're having discussion here.
That thing, he has so much knowledge. My brain is too slow to keep up with what he is saying. So I literally have to go half time and make all my notes. And then I totally get it. Then I'm like, oh my gosh, that's what he means. Okay, now I get it. Because
who are you talking about?
Some dude.
Forrest. He's not
amazing. The guy's almost memorized the law of nations. He's on point.
Yeah.
Well, it's kind of like Gene Keating. I transcribed like 21 classes, 2-hour classes of his, and because he would just go through stuff, and I didn't catch it at all. But when I transcribed it, then I knew what he was better,
Yeah. Yeah, but no, I'm finding that now I can actually read and understand what I'm reading. I do have to slow down on my reading to be able to do that, but that's okay because I think it helps everybody.
Well, thank you for another. So what is next week when we have this guest speaker?
So yes, Monday on the 8th, or is it 8th? Yeah, I think it's the 8th, right? No, the 10th? No, crap. What's the date? No, it's the 8th. It is the 8th. Yeah, the 8th is when Howard's going to show up.
So are you going to do Zoom, or how are you going to do it?
No, it's going to be on here.
Oh, he'll just come on there? You'll just check. He'll join the chat somehow.
He came on Monday, but like literally for 10 seconds.
You did?
And then made an appearance and said, "Hey, it's Howard. Okay, just wanted to pop in."
I didn't hear that. Yes.
Yeah, it was like before we started reading, he just popped in real quick because we were talking about it, and I swear his ears started to burn because he popped on, and I was like, "Oh, speak of the devil."
So he's signed into, he's in this room.
Yeah, I think he just signed in to see like how it works and everything. So. But yeah, get your questions ready, people.
Uh-oh. Homework assignment.
Yeah, right. All right. Are we done discussing the book?
Yep.
All right. I'm going to stop the recording.